Senator Whish-Wilson. Your time has expired. Senator Canavan.
Thank you, Mr Acting Deputy President. The American radio businessman David Sarnoff once said that competition brings out the best in products and the worst in people. That nicely sums up, in my view, the dilemma that we have in harnessing competition to deliver good outcomes without damaging our own ethics and morals. Competition is a means to an end. As consumers, we want cheap, affordable and high-quality products. The best way to ensure that is to have choice and competition. If there is no threat that I could change my custom from one business to another, there will be no desire for others to go to great efforts to deliver what I want. Competition ensures that businesses never forget that the customer is always right, and David Sarnoff was right that competition brings out the best in products. But the other half of the quote is true too. Competition can bring out the worst in people, especially when some businesses seek to stifle the competition that makes life hard. David Sarnoff himself, as president of RCA, had a large AM radio network in the 1920s and 1930s. The emergence of FM radio, invented by Edwin Armstrong, was a clear threat to Sarnoff. So he lobbied the Federal Communications Commission to make changes to the FM band, which rendered many FM radios of the time useless. And he tied Armstrong up in endless litigation, contributing to his suicide, that's Edwin Armstrong's suicide, in 1951. Not only that, the actions of RCA at the time put back the widespread adoption of FM radio for 20 or 30 years. So, although undesirable, the desire to damage a competitor is a perfectly rational response, and some element of it is simply the competitive process. I can't compete vigorously without risking damage to some individual competitors. Where there are winners, there will always be losers too. However, what we should not allow is businesses that seek to damage the competitive process as a whole, rather than just individual competitors. That is why I welcome the Harper Review's draft report, which was released on Monday. This has been the first comprehensive root and branch review of our competition laws for more than 20 years, and the review has made some recommendations to strengthen our competition laws, especially those concerning the misuse of market powers laws under section 46 of the Competition and Consumer Act. Their recommendations would prohibit a corporation that has a substantial degree of market power from engaging in conduct if the proposed conduct has the purpose, or would have, or be likely to have, the effect of substantially lessening competition in that or any other market. The Harper Review's proposed wording differs from the current wording of section 46. Under our current laws, to prove the misuse of market power, three things must be proved. First, that the corporation must have a substantial degree of market power. Second, the corporation must have taken advantage of that power. And third, the corporation must have acted for the purpose of damaging a competitor, preventing the entry of a person into a market or preventing a person from engaging in competitive conduct. The last two of these tests have become problematic, and the Harper Review's recommendations essentially seek to alter these tests. As the ACCC said in its submission to the Harper Review, as currently drafted and interpreted, the provision is of limited utility in prohibiting conduct by firms with substantial market power, which has a detrimental impact on competition. The most stark of these limitations is that for an action under section 46 to be successful, the complainant must prove that the action has been taken for an anti-competitive purpose. And the key word there is purpose. Because proving why I act is an incredibly high hurdle for people to meet in our courts. Proving that I didn't go for a run this morning, Mr Acting Deputy President, is a pretty simple matter. I didn't do it. But proving why I didn't do it would take lengthy debate. I would argue that it was simply because I was busy preparing this very important speech this morning, but my wife would probably say it's just because I'm lazy. The current wording of section 46, she's right, she is right, Senator Sterle. The current wording of section 46 is the competition law equivalent of proving intent in criminal law. It is a much harder thing to do. The Harper Review has recommended that the purpose test should be supplemented by an effects test. This would mean that corporations with substantial market power must not engage in conduct that has the effect of damaging competition. It is important to note here that there are two changes being proposed. The first is to make large firms with significant market power responsible for the effects of their decisions. Those that seek to oppose such a change must answer the question as to whether big businesses should take into account the effects of their decisions. Do large companies in our retail, financial and utility industries believe that they have an obligation to act in ways that promote competition rather than detract from it? The second change is that corporations will only be liable for the impact of their decisions on the competitive process, not on individual competitors. It is clear that the effect of some perfectly reasonable, indeed socially beneficial, business decisions will harm competitors. The very act of opening up a business will take custom from one business to another, thus causing harm. What we don't want, however, is damage to the competitive process as a whole. It is one thing to open up a store and compete. It is another thing completely to engage in conduct that is exclusionary, predatory or deters others from opening up a business lest they risk being subject to such behaviour. The Harper Review's changes will also remove the taking advantage test. The take advantage test has become too obtuse and hard to interpret. The test requires that the advantage be taken in respect of the market power a business might have. It is in effect another quasi-purpose test within section 46. You have to prove that a business acted in a way that gave them advantage and that they did so with the purpose of using their market power. The take advantage test has become one of great dispute in 4 recent competition law cases, including in Melway, Boral, Rural Press and Cement Australia. These cases have involved the courts launching into long hypothetical deliberations about the conduct of a corporation in a hypothetical world in which they do not enjoy market power. After 2 of these cases, the Parliament made additions to section 46 to clarify the take advantage test. As the Harper Review has succinctly summed up, however, it is doubtful that these amendments assisted. It is probably clear now that we simply need to remove such a test to remove any such ambiguity that remains, and that is what the Harper Review has recommended. Indeed, and the broader case that the Harper Review has made for change is strong and is supported by both logic and evidence. The first point to make is that the introduction of an effects test would not simply end up protecting inefficient companies to the detriment of consumers. Outcompeting our rivals by competing on merit would not amount to conduct that significantly lessens competition under the proposed changes. The ACCC Chairman Rod Sims reiterated this in a recent letter he wrote to the Harper Review, saying that section 46 should protect and promote the competitive process not by protecting the losers, but by preventing conduct by firms in a position of substantial market power that excludes efficient and innovative competition which would otherwise benefit consumers. I recognise that there are some that disagree with this view, but I think we can all agree on one thing. This debate should be informed by evidence, not by speculation, and we can use evidence in this case because we have an effects test both here in Australia and there are examples of effects tests overseas in other competition law regimes. Here in Australia, an effects test already exists in regards to the telecommunications sector. Part 11B of the Competition and Consumer Act specifically prohibits a telecommunication company with a substantial degree of market power taking advantage of that power with the effect or likely effect of substantially lessening competition. Overseas, an effects test is the predominant way that competition laws are enforced. The law in the United States prohibits conduct that unreasonably restrains competition by creating or maintaining monopoly power. Courts have largely interpreted this prohibition to only capture firms with substantial market power. The Federal Trade Commission made a submission to the Harper Review, and they stated in their submission that in recent cases, intent is rarely, if ever, the focus of the analysis. A subjective intent test risks attributing too much weight to hyperbole or unrealistic speculation, or too little weight to the harm from objectively anti-competitive acts. Over the past century, US courts have moved from using intent to an expressly objective effects test. The view was also summed up recently by the US Court of Appeals for the District of Columbia in a famous case as the US versus Microsoft. And they said in that case that to be condemned as exclusionary, a monopolist act must have an anti-competitive effect. I use that word effect. That is, it must harm the competitive process and thereby harm consumers. And that is exactly, it's a very nice summary of exactly what the Harper Review has recommended. The US Federal Trade Commission also notes that US courts apply the effects test pragmatically. and that the test permits flexibility of proof based on the context and best available evidence. Similarly, in Europe, they have provisions in their competition law relating to an abuse of dominance test. Under EU competition law, as well as in a number of European countries, including the UK and France, determining whether an arrangement is anti-competitive is assessed on the basis of its objective, like our test, the purpose test, or its effect on competition in the marketplace. There is a simple effects test right here for the opponents of an effects test. If the effects test is to wreak such havoc on our economy, then people should be able to point to the effect of the effects test in other countries and in our telecommunications sector here. Surely, if the effects test is so detrimental to competition, surely if it is to have such a chilling effect on the marketplace, that would have become apparent in the US and Europe, who have had decades of experience of such laws. In a recent unpublished paper on New Zealand's competition law, a competition law expert from Harvard University, Professor Andrew Gavel, noted that the omission of an effects test is inconsistent with trends in competition law internationally. He was highly critical of what he termed the counterfactual test, and that's the test that I described earlier that our courts have applied in trying to work out if corporations have taken advantage of their market power. Professor Gavel noted that the counterfactual test substitutes a hypothetical inquiry into the conduct's possible efficiencies for the more important question of its actual effects, both pro and anti-competitive, when practiced by a specific dominant firm in a market with specific characteristics. I think Professor Gavel gets to the heart of the issue when he says that the problem with the counterfactual test is that it never asks whether the anti-competitive effects are far more substantial than any realised efficiencies. That is, any efficiencies that would be associated with promoting competition or not regulating competition. Perhaps to put it in some plainer English, mainly because my parents and children are in the gallery today, I'm sure if they're still awake, what we're actually talking about is that the whole point of competition laws is to stop the negative effects of anti-competitive conduct and to promote the positive effects of pro-competitive conduct. We can't achieve this unless we're actually looking at the effects of that conduct, not just their purpose. As a legislator, I'm not interested in the state of mind of a big business. I'm not concerned about the intent or purpose of their actions. I'm interested in their effects. That is why we should have an effects test. We should have a competition law that is firmly focused on promoting the great benefits of competition, not on whether people are intending to act in a competitive way. If competition is a means to an end, why would we focus on the intent of actions and not their effect? I agree that competition is only a means to an end. It's a process to provide good things. But with that in mind, competition laws should be firmly focused on those ends that are actually achieved by businesses, not what their hypothetical objectives or ends might be. I agree with the ACCC. The proposed effects test is neither novel nor anti-competitive. I know that the recommendations that the Harper Review has made are now going out to consultation, and there'll be further submissions made on these. I certainly, as I've said in this speech, support the direction of the changes, but I too have some reservations about some of the proposals they have made. The Harper Review has provided some defences to an effects test. First, the Harper Review has said that a business could defend itself from a successful claim of misuse of market power by arguing that a rational business without market power would have acted in that same way. I'm concerned that this would simply put us in the same hypothetical hyperspace that marks current Section 46 cases, although I would note that the change they proposed would put the onus of proof on the business or on the defendant to prove that hypothetical situation, rather than putting the onus of proof on the plaintiff or the ACCC. Second, the Harper Review has provided an additional defence that the anti-competitive effect is in the long-term interests of consumers. I worry that that phrase is not well defined enough in our current laws, although it has been used in the context of access pricing regulation. Even so, more work would have to be done to clarify exactly what that will mean in this context. Overall, however, I applaud the Harper Review for suggesting these changes. Clarifying and strengthening our competition laws will be a shot in the arm for small businesses and farmers that are suffering under the yoke of too much market dominance. We should never put people in the position where they can basically be threatened or blackmailed into providing more and more every time. Business relationships are just like other relationships. They thrive best when there is give and take.